SJC-12350, Commonwealth v. John E. Cassidy, and SJC-12348, Commonwealth v. Tyreek A. Brown.
Good morning, Your Honors. May it please the Court, Attorney Deborah Reardon, representing Tyreek Brown. With me is Attorney Theodore Reardon. This appeal has two issues. The first one is that the Commonwealth improperly argued in its closing that the jury should find some kind of a romantic relationship between the defendant and the co-defendant in order to discredit the co-defendant's confession. There were two confessions. The defendant's confession was made under questionable circumstances. It was improper when there was absolutely no indication of a relationship, no evidence of a relationship for the Commonwealth to suggest to the jury that there was. And it was purely in an effort to discredit the co-defendant's confession.
Let me ask you on that. That we've had closing argument situations in which the person has misstated the evidence. This is not a misstatement of the evidence. It is arguably a reach with regard to an inference versus speculation. But where do we go if we are to evaluate every inference that a prosecutor makes and say that it's too weak an inference to argue and falls into the realm of speculation? Is that prosecutive misconduct to argue an inference which is too weak to be persuasive?
I would argue that it is. In this case, the only evidence was that the defendant went to his ex-girlfriend's house in Worcester to pick up his clothes, and that Cadiquette was the co-defendant. Female co-defendant was in the back seat of the car waiting for him. She did not go into the apartment. And that was all that the Commonwealth had to work with in making this inference that there was a relationship between them. There was another person in the car. There were three people in that car. And there was no evidence that anyone had a relationship with anyone else. So it's
right. I understand your argument that says that it was an inference so weak that it arguably could be characterized as speculation. The question is our role. I mean, do we then evaluate every factually true statement where we consider the inference to be speculation and say that may fall into the realm of a miscarriage of justice? I don't recall us having done that. I recall us saying the prosecutor misstated the facts, but I don't recall us ever saying the prosecutor argued something which should be viewed as pure speculation and saying that's enough to warrant a new trial.
Well, I would argue that it's even more severe than misstating the facts, where you're almost trying to create facts that don't exist.
But doesn't the judge instruct about inferences?
The judge does, and the judge gave the standard instruction here. There was no curative because there was no objection, and thus it would be a substantial risk of miscarriage of justice. I do want to go on to the next argument, though. And I would argue that the appeals court was correct in deciding that in order to convict the defendant of Chapter 269, subsection 10N, the loaded firearm enhancement to subsection 10A, that the Commonwealth needs to prove as an essential element that the defendant knew there was ammunition in the firearm.
You could sort of feel a reticence in the opinion, and it seemed to be based on the issue in Commonwealth versus Johnson and a lesser included offense for possession of ammunition flowing from possession of a loaded firearm. Why is Johnson dispositive of this issue?
Well, the reasoning in Johnson, that I think the reasoning is applicable here, and that is that in order to be convicted of although this is not a lesser included, in order to be convicted of the greater, section 10N, one has to be convicted of the lesser. The elements of the lesser have to be proven in the elements of the greater. And in 10H, the ammunition, there is a knowing requirement. So if you have, the only bullets are in your firearm, and you're being convicted of, and charged with carrying a loaded firearm and illegal possession of ammunition, then you have to prove all the elements of the lesser included, and then the extra fact that there's a firearm. In this case, it's not a lesser included, greater included. However, you have an enhancement with 10N. So you can't be convicted of 10N unless you're convicted of 10A.
Why then did in Jefferson, why did the court then say the issue was open in that footnote 7?
I'm not sure why they said that, except that Jefferson wasn't dealing with the exact issue that we're talking about here.
Well, no, I thought the footnote in Jefferson dealt with the sufficiency of the evidence to convict on 10N, but then it left the issue open about whether or not there was a known requirement.
They put that in a footnote, but the issue in Jefferson was not, it was interpreting whether you need to prove that you have knowledge of the bullets in the firearm. So it wasn't the same issue that we're arguing today. And they dropped a footnote to that effect, but if you don't follow Johnson, then what really the Commonwealth is asking you to do is to overturn Johnson.
Well, putting aside for a moment whether or not it's the lesser included offense issue is really dispositive, because what you have with Johnson, you have bullets in the loaded firearm, that's redundant, and possession of ammunition, so obviously you can't be sentenced on both. But most enhancements, there's not a knowledge requirement. The assault and battery on somebody pregnant, or there's not a knowledge requirement on an enhancement because of quantity of drugs. Why in this particular situation should we, and it's not in the plain language, infuse a knowledge requirement?
Well, in the past, and historically, this court has read a knowledge requirement in when it was not explicitly stated, and I see that my time is up, but if I could answer the question. So historically, the court has read knowledge into as a requirement. And second of all, in interpreting statutes, mens rea is the foundation of criminal law, that you have to have mens rea to be convicted of a crime.
Well, we've got another case on that today.
So,
Yeah, if I could ask you, that we do have Commonwealth versus Poro, which I happen to write, not discussed in any of the briefs, does identify certain, not many, but certain crimes which are viewed as lesser included, although they don't have a perfect match as to the elements. That is, one assault and battery, one kind of assault does not perfectly match the elements of assault and battery, but yet we still view it as a lesser included if there's no touching. Indecent A and B versus rape of a child, it's 16 versus 14, but we still view it as a lesser included. Is this just one of those exceptions to the usual rule?
in that,
I mean, the argument that the court below gave is that Johnson requires that it be a lesser, it have the knowledge requirement because it must be a perfect fit, and there are some cases which are not perfect fits, and maybe this is just one of those cases where we say it's not a perfect fit.
well, even without the knowledge, even without the perfect fit, many courts, including the Supreme Court of the United States, have found that if you're going to enhance a penalty, you're going to give a more severe penalty, you have to have more severe culpability. And in this case, where one could not see the bullets in the firearm, that one could be in possession of the firearm without knowing that there are bullets in there.
But isn't it logical that the legislature would say possession of a firearm, loaded or unloaded, unlicensed, is a crime, and then we're going to give you enhanced penalties if that firearm happens to be loaded?
Well,
Isn't that more culpability?
but with that culpability comes the requirement that you prove that you knew there were bullets in that firearm.
Well, I guess we'll find that out.
Yes, we will. I'm a little bit confused about the clock here.
No, that's all right. We've given you, we've asked you questions, so your time is up, but we have asked you questions. It's not your fault.
I wish I
So
had more time to
You've done
discuss
just
this
fine.
one, but-
You've done just fine.
Otherwise,
So-
I'll rest on my
All right.
brief. Thank you.
Thank you. Ms. King?
Good morning, Your Honors. Michelle King, Assistant District Attorney for the Commonwealth. When you look at the plain language of this statute, as you must, it's clear that when read together, Sections 10A and 10N, 10A requires a mens rea requirement of knowing possession of a firearm, while 10N has not, the legislature has not put in a mens rea requirement.
I think that the chief may have alluded to this inside in the Quiro case, but do we have to decide, if we go your way, are we then bound by, do we have to overrule Johnson and say it's not a lesser included offense?
No, Your Honor, I don't believe that you do. And the difference is that in this case, when you look at A and N together, the legislature has clearly set out that they want an enhanced sentence under Section 10A for when you are in possession of a loaded firearm. The court in Johnson in footnote 11 specifically noted that the legislature did not provide such an enhancement when you looked at Section 10H and 10N. So those two are not read together. So 10H is a standalone statute, while 10A and 10N are read together. So I would suggest to you that the difference is that the legislature specifically wanted an enhanced sentencing for Section 10A, but did specifically not provide that, as this court noted in Johnson, under Section 10H, and that's the difference. And so I would suggest to you that you do not have to overrule Johnson. In Johnson, the court talked about it being a duplicative conviction and sentence, but in footnote 11 in Johnson, it specifically said that that was different under Sections 10A and 10N. So I would suggest to you that you do not have to overrule Johnson in order to find in the Commonwealth's favor in this case. Now, after you look at the plain language of the statute, which clearly does not have a knowing requirement in Section 10N, if you look at the reasoning perhaps why this court should not infer a knowledge requirement into Section 10N when it did in Section 10A and 10H, as this court did in Johnson for 10H and in Boone and Jackson for Section 10A. The difference is that in doing so, if you did not infer knowledge in Sections 10A or 10H, as the courts eventually did, that would create a strict liability statute for those sections. And strict liability statutes are strongly disfavored. However, in this case, if you declined to add a knowing requirement for Section 10H, a strict liability statute would not be created. The United States Supreme Court has said in the Freed case that as long as there is a mens rea requirement for at least one element of a crime, that failure to have a knowing requirement for every element does not make it a strict liability statute. So declining to add a knowing requirement for Section 10H would not create a strict liability statute, and I would suggest to you that that is a very important difference in this case when looking whether or not a knowledge should be inferred.
Now, is it your view that the prosecutor could choose to charge knowing possession of ammunition as a separate count and then not seek the enhancement?
Yes, Your Honor.
So, but if you seek the enhancement, you lose the ammunition count.
Correct, and that's how it has essentially played out in the Commonwealth. Anytime a defendant has been charged, as in this case, with a crime under 10A, 10H, and 10N, the charges of under 10H are dismissed. So the defendant cannot be convicted of 10H and 10N, but can be convicted of 10A and 10N.
And as you point out, I think in your brief, as it relates to the knowledge requirement, that knowingly possessing a firearm for 10A, you don't have to know the length of the barrel. You don't have to know even that it's illegal to possess the firearm.
Correct, Your Honor. And again, it goes to the difference of this statute being, the difference, I think, that really makes this statute stand out is that it's a sentence-enhancing statute. And as Your Honor noted earlier, that many of the sentence-enhancing statutes do not have a knowledge requirement. And if you look at this court's ruling in Rodriguez and Sabetti, that those two cases talked about the knowledge requirement for a defendant who is convicted of distributing drugs. The sentence enhancement happens with the amount of drugs that are required for the sentence. And the courts in Rodriguez and Sabetti were very clear that there is no knowledge requirement as to the amount of drugs, the knowledge requirement that's in the statute under Section B, but not the subsequent subsections, relates only to the defendant's knowledge of the possession of the drugs. And I would suggest to you that that is precisely, although obviously different sections of different statutes.
Isn't it a little
on point.
different, though? Because with drugs, if you know you have drugs, it doesn't matter the amount. But in this case, you don't know whether or not you've got the ammunition.
I would agree, at least in part, that's slightly different. But again, I think when, I would suggest to you that when you looked at sentence enhancements, that the legislature here very clearly wanted to provide for an enhanced sentence regardless of the actor's knowledge of the ammunition within the firearm. And if you look at the case out of the Supreme Court of Michigan, the Quinn case, that court went very specifically through cases where knowledge that a firearm is loaded is not required, particularly because there's a string of United States Supreme Court cases that talk about public welfare statutes that were enacted specifically for public welfare, and that you need, essentially, the defendant possesses a loaded firearm at his risk.
Do we have to worry about Buckley that says that mens rea requirement is presumed even if it's not actually in the statute?
Again, I don't believe so, Your Honor, because this is a sentence enhancement statute, and that's what sets it aside. If there are no further questions, I'll rely on my brief.
Okay, thank you.
Thank you, Your Honors.
Mr. Cassidy, good morning.
Good morning, Chief Justice and Justice of the Supreme Court. My name is John Cassidy. I'm here today in regards to the 7 convictions which relate to possession of firearms in Massachusetts. I do think my brief is clear on my end. However, I'm not the one reading it, I'm the one writing it. I do think that none of my convictions should stand. There's 7 convictions. The 10H.
Let me ask you a specific question, Mr.
Yes, sir.
Cassidy. One of the issues that you heard in the last case, and we're going to talk about in your case, is this knowledge requirement, knowledge of the large capacity magazines and firearm. But when I read Judge Cosgrove's instructions in your actual trial on the second day, my take from it was that he did instruct, pursuant to the plain language of the statute, that there had to be a knowledge requirement. So even if you're right, are you wrong that it doesn't affect your conviction? That's what I'm confused about, because nobody really spends a lot of time talking about Cosgrove's actual instruction that went to the jury.
I'll admit that I did not review that instruction before coming here. I will admit that I did review the discussion at the end of the first day where the district attorney and my attorney are talking to Judge Cosgrove, and I believe that the district attorney admits that he does not have a definition for assault weapon instruction or large capacity, and he just kind of made his own, which could absolutely be the practice. I don't.
Right, what Judge Cosgrove instructed was that the Commonwealth had to prove that the defendant knew that he possessed or had under his control a large capacity weapon. And then on the feeding device said the Commonwealth has to prove the defendant knew that he possessed a large capacity feeding device.
And again, I think it goes to the characteristics of large capacity and assault weapon. I think that they needed to instruct on that.
You think so? Your argument is it had to be more specific than what he instructed?
Exactly. I think if you look to the cross-examination of, I think it's Craig Pimenthal, the armorer, he, on cross-examination, he admits that he, of all 5 clips, not a single clip did he ever take the time to number loads. He never loaded.
But as you know, it just has to be over 10, and they were 30s, right?
I think it was.
The handgun was a 12.
It's over 10. He never loaded a single. He didn't load 1. He didn't load 5. He just looked at it and said, "Yeah, that's large capacity."
And if it's this big, I mean, I imagine.
I agree with that. There's such things as magazine stops, which I think there's actually firearms in Massachusetts that are large capacity, and then a magazine stop is installed, which limits it from this big to this big based on that. But the characteristics I think matter. If the characteristics do not matter, there's no grace period to own these weapons. So I could have been moving up here with a U-Haul, been pulled over. The way I was raised, if you're pulled over by cops, you have a firearm. That's what you're supposed to do. So if I get pulled over and I tell a cop, yes, I got firearms in the vehicle, essentially, if you're a diehard police officer, not to say negative connotation, you're arrested right then on the spot, and you've been in the state 10 minutes. I think that's probably a privilege and immunities. You're supposed to be a welcome guest, not an unwanted alien. I also think that if you're talking about taking my weapons, which I purchased under federal law, under Texas law, legally, when I purchased the weapons, they never mentioned large capacity, never mentioned assault weapon. So now I come to Massachusetts, and they're statutorily redefined. So I think that makes a difference because they've been redefined by the statute. If they weren't the characteristics of holding 10 or more or an assault weapon, then my in-home possession is a statutory exemption. So I would have never been charged.
You've answered my question about the Cosgrove instruction that it wasn't specific enough, and I don't want it to take away from the rest of your time if you have your other issues.
Sure.
Unless other members have questions on this topic.
I mean, that's probably the link. Yes, sir. Your Honor.
What do you say the law should be in terms of what the knowledge requirement must be?
I think that you have to know what you're possessing. You don't have to know a firearm within the general term. I think you have to know that you're possessing a large capacity weapon. You have to know that you're possessing an assault weapon. And I know there's saying that the district attorney's brief says that could practically be impossible to prove that a criminal defendant knew he was possessing a large capacity weapon. I would rely on the Shea case, and there's a couple other cases in there. It's the First Circuit case that talk about you're already guilty of a principal offense, the vicious will of robbing a bank, the vicious will of assaulting somebody or committing an armed robbery. You're already guilty of that. So how can you now say, well, I didn't know that was a large capacity? I think your knowledge is imputed, if that's the right word, that you already committed offense. You cannot say now that, oh, well, I didn't know that was an offense. I think that's one reason there's not a lot of good case law in Massachusetts. Most of the cases deal with some other crime being committed at the same time. And then if you look at some of the pretrial documents, some of these defendants, they denied ever owning the firearm. They denied it wasn't theirs. But then that's denied, and then it comes to trial, and they seek to rely on the Second Amendment. It's disheartening to someone who wants to rely on the Second Amendment to protect themselves when they haven't committed any other crime. I think that there is a higher threshold when all you know is legal conduct, and your arms have been redefined, and not just redefined on a long-term level, but recently, I know 1998 is when they enacted the assault weapon ban, or the assault weapon statutes in Massachusetts, and as well as large capacity. Prior to that, if I would have been in law school in 1996 with these same firearms, would have not have been a crime.
But I guess my point is, we generally don't require knowledge of the law, and large capacity and feeding device, large capacity weapon have a precise definition in the law, and it would be awful hard for anyone to prove that that one knew the legal definition and knew that what you had was in excess of, or met that legal definition. So how do we accomplish what you're trying to say without necessarily saying that the Commonwealth must prove that you understood that the law defined it this way and that what you had met that definition?
Then I guess I would ask that you would rely on the Second Amendment and saying that lawfully purchased arms possessed inside my home as a new resident of Massachusetts is legal exercise, is a peaceful exercise.
Would it be that the government would have to prove that you knew that the magazine could hold more than 10 rounds? If you come to Massachusetts with a big banana clip, kind of obvious, isn't it?
You would have to know that is regulated. I think that had I known these statutes prior or learned about them within 10 days of coming here, and I applied for the license, I could have got the license, and I would have been qualified, and none of these convictions would have stood. That's what seems weird to me, is that I'm able to own all these arms in Texas, in Massachusetts. It's just the fact that I failed to timely apply for a license. I failed to fill out paperwork and file them. Had I done that, I would have never run afoul of the law. If I did run afoul of the law and my application was denied, I can, under 129C in Chapter 40, I can lawfully surrender those firearms and I'm not prosecuted, or I can transfer them out of state. I see it's blinking. There's a couple more points I want to make. I don't want to get cut off. So if I can just switch to a couple things. Chief Justice Gantz, when we were talking about the generally knowledge of the law, I would point to the grand jury minutes, which I have a copy of if you guys do not. After there was the Detective Olvera, he presented his argument, his testimony of the firearms. He was asked by one grand juror one question, is that are assault rifles illegal in Massachusetts? And the detective responded that without a class license they are. And the next follow-up questions was, did he know that? So I think if you're talking about the ordinary knowledge of somebody, that's what a grand juror is. And they realized that, did he know that? Of course, the answer was yes, but I can't imagine saying no. The last thing is, I think if we talk about the Kumo and the Kolb cases, which I know December 5th there was a Second Amendment argument, if we say that assault weapon bans in large capacities are upheld, which is what the federal circuits are doing currently, although the Maryland, the Connecticut, New York statute have grandfather clauses, which would have shielded me had I been prosecuted. And I guess I'll quote the City of New Orleans versus Duke's case, which says grandfather clauses are long accepted legislative tools for mitigating the effects of new regulations on persons who have relied on existing case law. And I will end with Justice Lipa's dissent in the 2012 Shaw case, where he says, although the government may face a tougher burden in close cases, we believe that is exactly what the Supreme Court has held Congress intended, because the close case is exactly when you run the highest risk of convicting someone whose conduct will not even alert them to a probability of strict regulation. And obviously he's quoting the Staples case.
All right, thank you, sir.
Lastly, in the Jorge Ramirez case.
Go ahead. I'll give you a minute more, but you're over your time.
In the Jorge Ramirez case, you asked if there is a federal case that that applies the Second Amendment to the carrying, and that defendant's attorney said no, there actually is. It's I submitted it to this court. It's the July 2012 case on Wren v. DC. So there is one circuit that has expanded that. Thank you guys for your time and for the clerks.
Thank you. Ms. Lee.
Good morning. Mary Lee, Assistant District Attorney for the Bristol District for the Commonwealth. The primary question in the Cassidy case is whether the Commonwealth must prove that the defendant knew the physical characteristics of the firearm under Section 10, small m, as in Mary, whether he knew these firearms were a large capacity. And the answer to that question is no, based on the recent legislative history of Section 10, as well as specifically 10M
Let's look at
and the purpose.
the words of the statute. It says, any person who knowingly has in his possession, comma, and then talks about, or a vehicle, but let's put that aside, a large capacity weapon or large capacity feeding device. In your view, what does the word knowingly modify? Doesn't it have to modify or speak of one's knowledge of a large capacity weapon? How could it just be the weapon?
No, it's an adverb, so it modifies the verb. The verb is to possess. Had the legislature wanted to modify large capacity, then they would have used language like has in his possession an item known to be a large capacity weapon. It's very easy to put the modifier in the correct place if that's where the knowledge requirement is. But this is an adverb modifying the verb, and that's how it was construed in O'Connell.
So you knowingly possess what?
Exactly. And so then you go to the O'Connell case in 2000, which this court said that you don't have to know the physical characteristics of the sawed-off shotgun. That is subsection C, and as the very ably written CPCS amicus brief points out, C does not have the word knowingly in it. But I would note that this court in O'Connell added in the mens rea requirement knowingly and put that into 10C, saying you had to know that you had a firearm in your possession. And then if we can then talk about the legislative history argument, Section 10 was then amended in 2006 after O'Connell, and the legislature did not change that analysis in O'Connell when Section 10 was amended.
Let me ask you about the statutory definition under 140, Section 121. So if I'm a law-abiding citizen and I have a semi-automatic handgun, and I get it lawfully, and the way and I have a magazine that holds 9 rounds, so I'm compliant. The way 140, Section 121 reads is a weapon capable of accepting a large capacity feeding device runs afoul of the law.
Yes.
Of the law. So the 9mm I lawfully own has the capacity to accept a 12-round or a larger magazine. Am I violating the law?
So the question is whether the legislature can put the onus on the possessor of the gun to know the capabilities of the gun, to know the killing power of that gun that he owns. And so, yes, if that gun is determined by an expert to be something capable of being modified, being capable of being 10 rounds or more, then yes, it would fall within the statute.
Every single 9mm lawfully owned by anybody in the Commonwealth is illegal?
If there's an expert who says that that gun that you own can fit within the definition of a high capacity, large capacity firearm, then
How hard is that to find an expert that would say that?
and well, I would suggest to the court that's the question here: is did the legislature put the onus on the owner of the gun to make sure that the gun that they own is not large capacity, and if it is, to fall within the correct registration and licensing requirements. And I would suggest the legislature has said that's what they want to do, because after O'Connell came into play, and after Section 10 was then amended again, then the appeals court in unpublished decisions applied O'Connell to Section 10M and said that there was no requirement of proof that the Hang & Gordon are cited in the Commonwealth's brief. There's no requirement for the Commonwealth to prove the large capacity knowledge for the defendant, and this court denied further appellate review in those cases.
Did Mr. Cassidy get the benefit of a more favorable instruction from Justice Cosgrove?
This court would have to determine. You read Judge Cosgrove's decision, and it sounds like Judge Cosgrove gave something more favorable, although it's in line with the statutory language of Section 10. So this court would have to determine if you If you change the analysis under 10M, this court would have to make the determination whether Judge Cosgrove's instruction was sufficient under whatever new analysis. I'm suggesting this court should not change the analysis, because then in 2014, after Heng and Gordon, the legislature amended specifically 10M again in two places, one in the licensing requirement and one in the eligibility for probation regarding a person's age, and that was in the wake of Miller versus Alabama. And in that situation, when the legislature amended 10M, and O'Connell's out there, it's been applied to 10M, and the legislature did not change that language, which could easily have been done to a person has in his possession an item known to be a large capacity. They didn't make that change. They could have. Then the legislature is presumed to know how that statute was being interpreted and to adopt that interpretation when amending the statute and by making no change to the language. Dayton is this court's decision on that. That does not just apply to published decisions and decisions of this court. The interpretations of the legislature's statutes are presumed to be known by the legislature when they amend their cases. I would point to, in McCarty's case, which is not in my brief, I'm sorry, it's 445 Mass 361 at page 368. Justice Sossman wrote a concurrence saying, I don't like how this statute was interpreted by the Industrial Accidents Board, but then the legislature amended it after and thereby adopted this bad decision of the board, so we're stuck with it. And this court said similar things, and so that's on a board, not even the appeals court. These are appeals court decisions that were denied further review by this court. That happened again in Rosing versus Teachers. It's 458 Mass 283. That's a 2010 case. You find that at page 293. And Pavian versus Hickey, 452 Mass 490 at page 494, 2017 case. So I would suggest the legislative history of 10M shows that the legislature knows exactly how the mens rea is being applied in 10M and has adopted it, and that's the correct language. And you shouldn't be, I would respectfully suggest this court should not be changing that analysis at this point where the legislature, it's the legislature's job to change it.
So tell me what the elements are of 10M.
I think the elements are that the defendant has to knowingly have in his possession a firearm, and that firearm has to meet the statutory definition of large capacity, and the onus is on the defendant to accept that responsibility for knowing the killing power in his hands. The legislature has the right to do so. This is a constitutional statute, and the legislature has the policy considerations to try to prevent mass killings, and this is one way they can do it. And this is an important statute and an important mens rea that was limited by O'Connell, and I would ask the court to make no change in the law, but if you make the change in the law, to find that Judge Cosgrove's instructions were sufficient in this case.
And it complies with the Second Amendment, even if, under your interpretation, every single semi-automatic weapon is capable of accepting a large capacity feeding device and could be illegal.
Because they're regulatory as opposed to outright bans, and the defendant knew the regulation process in this case. He said that he didn't want to get his license here in Massachusetts for these weapons because it was a financial consideration. He didn't have the money for it. So this is not a vague statute. It is not unconstitutional, and it has a mens rea requirement, the one in O'Connell that's been adopted by the legislature.
But what do we do, going back to Justice Gaziano's earlier question? I would feel better with your argument if the statute read, any person who knowingly has in his possession or a firearm that is a large capacity firearm, but that's not how the language is drafted. It says knowingly has a large capacity weapon. So the word firearm is not in the statute.
Yes, but the fact that the legislature has used an adverb and given the legislative history and the very important policy that the legislature...
Let's carry the adverb argument. So you say knowingly...
Goes to possess, to has.
But possess what? That's...
Right,
And it also says notwithstanding Section 10A.
Yes, it's a standalone statute, unlike Section 10 in the Brown case.
And you don't have the virtue of this being an enhancement. This is a
This is a standalone crime, yes.
standalone crime.
So I would rely on the very important public policy arguments protecting public safety and this recent legislative history that the amicus brief from CPCS did not address. It only addressed when the statute was enacted and not what has happened since.
Okay, thank you.
Thank you.